Welcome back to Court TV Live. We've got some big breaking news in the Ferreter case. Maybe I should call it a big faux pas in the Ferreter case, because the question from the jury is more of an alert to the judge that the jury got evidence they weren't supposed to get. They reviewed videotape evidence handed over by the defense. So this is a defense mistake. Video evidence they were not supposed to see. It shows the child victim in this case, being handcuffed, which is protocol with police with a child runaway. But if you don't have that context, it looks like the child's being put under arrest. The jury wasn't supposed to see that. Let's go into the courtroom. We're going to rewind the tape back so you can hear the moment when the judge learns of this big blunder.
All right, I'm advised that the jury has apparently had a piece of evidence reviewed that was not in evidence. I don't know how that happens, but it apparently was the arrest of the defendant. So let me hear from, excuse me, the victim. So how did this happen?
I don't know, but they put into, Your Honor ruled that they could just put in a picture of him or like a showing what he looked like. And on the USB that they put into evidence is 2 files. And then the other one also says he's going to be arrested, and they said that they published it. I don't think you guys even published this.
There's been no publishing of an exhibit where he was arrested. The victim?
What happened was we had a video when he was originally in school. We went sidebar. The court said we could play a trimmed version of it that just shows what he looked like at the time on that date.
That's right.
And we trimmed it. However, inadvertently, when that jump drive went into evidence, the longer version wasn't deleted out. So there was 2 files on there instead of just the one that says trimmed.
So how does that happen, Mr. Waheed? Isn't that on the defense? That was your exhibit. You were required and responsible for making sure that what was admitted in evidence and what was published was to be on that thumb drive. And now I'm hearing that they have seen something that was not admitted into evidence?
That is all correct, and it is our responsibility. I'll take responsibility for that. That was the day. That was the first day. It was a very, very busy day. As we moved through the day, it was completely inadvertent. I think I did the crosses for everybody that day, so I didn't really look at that evidence at the end of the day when we were trying to get it to Madam Clerk. So that was a mistake.
All right, Ms. Coakley, what's the state's?
I think it needs to be an instruction to the jury to disregard it, and it also is factually inaccurate what they had it characterized as, because he wasn't arrested. He was just detained and never arrested. So to indicate that he was, like, there was just police procedure that he was detained for a moment and put in cuffs. There was no arrest here. So to indicate that he committed some type of crime for which he's arrested now, based on how they have labeled this, which they provided to the jury, is really problematic. And you know, they had to play it without any sound. I had to play a video without any sound because unfortunately I advised him that and he didn't send that back.
Well, to say that I'm displeased with this development would be a massive understatement. This trial is, we're in the 9th day. I rely on the attorneys to make sure that the evidence they submit, and based on my rulings, properly reflects what my rulings are, and that the jury sees only what has been admitted into evidence. Let me hear your position, Mr. Waheed, on the state's request for limiting instruction. I assume it's going to be something to the effect that, well, one, the exhibit's got to be corrected. The proper file has to be put on the thumb drive. Secondly, it would be an instruction that, to the extent that they have seen documents or videos that were not received properly into evidence, they're to disregard that. And also, your concern is about the nomenclature of the file name, right?
Like a factual stipulation that he was not arrested, it was just police procedure for a runaway.
Okay. Your response, Mr. Waheed.
Just to be clear, the right evidence is on the thumb drive. It's just that the untrimmed version was still left on it. So I just wanted.
Well, how can you say that? If you say the right evidence is on the thumb drive, and now I'm dealing with a situation where the jury's reviewed something that they were not supposed to have reviewed, which was not in evidence, those two things don't mesh with me. I mean, either the pared down video is on it or an improper video that includes something more is on, right?
They're both on it. That's my point. That's all I'm trying to just say. So I agree with the state that the longer version needs to be deleted. I also agree with the state that my recollection is the court's ruling was to play it without audio. So it would be something that doesn't go back to the jury that they would have to play out here without audio, just like one of the state exhibits. I also agree on a limiting instruction.
Okay. All right. So, Mark, I want you to retrieve the thumb drive that they were reviewing.
State has it.
Oh, you already have it?
Yeah, and the state's also asking for a factual stipulation, because it creates, what is on there, what they've seen is him getting handcuffed and led to a police car. Which is factually false. He was detained because he ran away.
Well, I thought that I heard Mr. Waheed not object to my limiting instruction where I would advise the jury that the victim was not arrested. He was just simply detained as part of the normal practice in dealing with runaways.
That's correct.
All right. You can go ahead and bring them out.
Give me a moment, Judge. We're just going to fix this.
Okay. Well, that doesn't need to wait. You can do that and not take up the time of the jury on that.
Here.
And we are waiting for the queuing up of the replay. All right, you may bring them out.
Oh my. Oh my. I mean, this is so bad. What just happened is so bad on so many levels. I guess I could call it carelessness. I mean, the attorney's apologizing, but how does this happen? As the prosecutor said, with even the labeling being inaccurate, the labeling, calling it an arrest, which it was not. A detention's very different. And submitting that in, you could tell that judge was disgusted. So this could certainly be grounds for a mistrial. The state could move for a mistrial, but here's the pickle they're in. They're winning. They've got the evidence against this guy. They've got him. They've been able to check every box, no pun intended. So why would they do that? Instead, what the judge is going to do, he called it a limiting instruction. Sometimes you hear the word curative, a curative instruction, meaning like cure the problem, where the judge will say, members of the jury, you are to totally disregard what you saw. It has no bearing on this case. It's not a fact in evidence. By the way, he wasn't being arrested. It was a detention because he ran away from home, which they already knew. This is so terrible. I am just stunned and amazed at what we just witnessed.